We are going to be looking into the Constitution Act of Canada, more specifically the Constitution Act of 1982. This Constitution Act is the supreme law of Canada. This Constitution Act brings forth both sides of the law. It expresses our natural fundamental rights as individual human beings, and it brings forth the rights and privileges of the artificial person. The Constitution Act of Canada 1982 has a duality of nature. It expresses Canada's obligation to respect and ensure our individual absolute rights. However, it also brings forth the operations of law that attach to statutory creatures, driver, consumer, etc. In our case, when it comes to dealing with our fundamental human rights, the Constitution is the expression of the international obligation that the state party Canada had to implement our fundamental human rights and freedoms in domestic law. International Covenant on Civil and Political Rights, Article 2, states that each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. Canada, as a state party and a signatory to these covenants, had the obligation to bring forth the rights and freedoms enumerated in these covenants through the constitutional process. In 1982, Canada fulfilled these obligations by creating the new Constitution Act of Canada, called the Charter of Rights and Freedoms. This new Constitution Act was built upon the foundation of the International Covenants and International Bill on Human Rights. ASN v. British Columbia confirmed that the Charter should be presumed to provide at least as great a level of protection as is found in the international human rights documents that Canada has ratified. There are only several laws that really matter to us as human beings in this Constitution Act of Canada. The following list of articles of law which are drawn from the Constitution Act of Canada, 1982, is what is important to study and understand when it comes to our fundamental human rights and freedoms. Article 7 states that everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Everyone has the right to life. We know that everyone here in the Charter refers strictly to the human being, and this everyone has the right to life. A human being has the right to life. Now, somewhat take this interpretation as meaning that no one has the right to kill a human being. However, this is not what is being brought forth. If you do not have a foundation in understanding fundamental human rights and freedoms, in understanding Canada's obligation towards international covenants, and in understanding what has transpired with our designations here in Canada, this verse might not mean much to you. As you are aware, our designations in law have been changed. We are no longer considered a free human being, but have been rendered statutory creatures, a legal entity within the law. The legal entity is something that is created by law. It is not something that is born into existence. Since it is created by law, it is not living, it is not alive, and it does not have life. If I take recognition as this person before the law, then I am not alive. I am not a human being, I am a person before the law, and I don't have to play that designation. The International Covenant states that I have the right as a human being to take recognition as a person, but not an obligation. Thereby, I have the right to life in law. Article 16 states that everyone shall have the right to recognition everywhere as a person before the law. Everyone, human being, shall have the right to be recognized before the law as a human being and not a statutory creature. This is our absolute right. The law must recognize us as men or women without any additional obligations or duties attached to us that flow from statutory law. This is how your absolute right operates. When we further look into the Constitution Act of Canada, we find an interesting article of law in verse 26 of the Constitution Act. It states the following: Article 26. The guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. This is clearly teaching us that the Constitution Act of Canada guarantees us directly certain limited rights and freedoms. However, these listed limited rights and freedoms do not mean that Canada does not recognize other rights and freedoms that are in operation here on the state party's territory. The fact that Canada did not include them in the Constitution Act of Canada does not mean that Canada does not recognize that. If Canada had not included Article 26 in the Constitution Act of Canada, then they would have been guilty of breaching the international covenant, which states that no person or no state party can perform any act aimed at the destruction of the rights and freedoms listed in the covenants. By including this specific article of law and drawing it up the way they have left the door open for anyone to call upon any of the rights enumerated in the International Bill on Human Rights once they understand and comprehend their position. Article 52(1) states that the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. As you can see, the Constitution Act of Canada has been declared to be the supreme law of Canada. Any law that does not follow the provisions of the Constitution is of no force or effect. If we can prove that the law that is being used against us is against the rights and freedoms as enumerated in the Constitution Act of Canada, then this law is of no force or effect upon us. You have learned recently that there is such a thing as natural rights, natural law. You have also learned that the government can create laws which are called enactments or regulations. It is the legislators of each province who write up or draw up these laws. According to Article 32 of the Constitution Act of Canada, this charter applies against a legislator of the government when they are creating laws. If the government creates laws through enactments that are against the charter, they have not fulfilled their obligation under Section 32. We as individuals can invoke Article 52 and declare that the law, the enactment that the legislator brought forth, is of no force or effect. In Article 24 of the Constitution Act of Canada 1982, it states that anyone, the player or subject that is brought forth, is anyone. Anyone whose rights and freedoms as guaranteed by this charter have been infringed or denied may apply to the court of competent jurisdiction to obtain a remedy. If through your due diligence and research, you have come to find out that your individual fundamental human rights and freedoms are not being respected through the laws of the government or created by the enactments, you have the right to declare this law of no force or effect against you and to seek a remedy in a court of law concerning what is transpiring against you individually.